Welcome to Legal Beagle.
Hello there. Today we are here with attorney Kristina Lyke on another fabulous episode of Legal Beagle. Attorney Kristina Lyke has almost 19 years of experience in family and criminal law. My name is Kevin Rosenquist, and today Kristina is going to share some wisdom on the topic of, is the order you receive from the court final? So thanks for being here today, and welcome to Legal Beagle. Let's dive in. Kristina, welcome.
Thank you. It's nice to be here again.
So interesting topic here. Let's. I'm excited to get going on this. So in family law, once you have an order, is the case finished?
So not necessarily. A lot of individuals believe that the order is a final order once they receive an order, but there are temporary orders. There's final orders. There's also orders that are regarding custody and parenting time. And as we go into further details today, we'll learn a little bit more about that.
Okay. Well, let's do it. Are there ways of changing an order of the court? And if so, how does that happen?
Well, first of all, I want to talk about the orders itself. I want to make sure that individuals understand that, as we talked about previously on another podcast, there's custody orders and there's parenting time orders, and there's also child support orders. Those are always modifiable, right? And then there's spousal support orders, and those, depending on what the circumstances are in your order, those can be modifiable too as well. Now, as to orders in of itself, now, if we're dealing with a temporary order or if we're dealing with the interim order or a final order, we want to make sure which one we're dealing with first. But there are different ways of actually handling this. So let's take an example of a judgment of divorce. A judgment of divorce is a final order, right? So everyone thinks that, and I just had a case similar to this. I've actually had a couple this year to do motions to set aside the judgment of divorce or actually get some relief. And I've either been defending it or I've been actually presenting the motion in of itself. And so there are a few things that I like to go over with, and it's for grounds for relief, you can actually, anytime that there's a clerical error, you can always go to the court and motion the court to have a clerical error to amend the order. So if you have like something like it should be an is or that, you can always amend the order to have a clerical order, right? And the courts can always, sua sponte, go and change an order too as well. They can also change an order if, for instance, like a defendant did not get served and there was no notice, and perhaps there was intentional no notice, and the court can see that and observe that. So sometimes they'll change the order and set aside the order, or they'll give some kind of relief to the defendant. A lot of times we look at one of the court rules and we look at, can they relieve a party or do we have to set aside the whole judgment of divorce? And there's a couple ways of handling that. Like the first one is mistake. So if there's a mistake or basically a surprise, excusable neglect. I had a case that just recently that the defendant got on the stand and actually said, I was surprised, right? And it wasn't really emphatic or anything of that nature. So I used that as a cross-examination tool because you were surprised that it didn't get paid, but you were in charge of it. How could you be surprised, right? So another one is excusable neglect. And then we have what is called newly discoverable evidence. That's something that you couldn't obtain before that order was actually entered. And then we look at fraud and misrepresentation of the court. When it's fraud, there's fraud that is upon the court, and then there's fraud that you can do with a third party. So it's called intrinsic fraud and also extrinsic fraud. So then we have what is called the judgment is void, right? And then another way to set aside or maybe get some relief, actually to get relief from a judgment of divorce, is actually to look at the judgment and see if it's been satisfied already. So if all the terms have been satisfied, then maybe this isn't the order we need to have, and this is the final order. One of the examples is like doing a motion to get relief from a judgment of divorce because of the fact of fraud or excusable neglect or maybe surprise. And an example of that would be, for instance, the individual stated that you didn't know about the property taxes not being paid, and that property was awarded to that individual. Yet that individual, and the defense would be that individual knew from the get-go that those property taxes were not paid, right? So the judge actually will do an evidentiary hearing, and when it comes to fraud, if it's on a fraud issue, you just don't go and amend the order or give some kind of relief. You actually have to set aside the whole judgment of divorce, and you may have to have another trial or go through the whole negotiation process all over again. So it's I want people to be watchful of that, because especially if somebody doesn't go and disclose things, we talked about that before in another episode of disclosing things. You always want to be upfront and honest. Make sure you're disclosing all of your assets and liabilities. And then there's another, if I'm going too fast, let me know, but there's another.
No, I'm with you. I'm staying with you so far.
All right, sounds good. In order to file something like this, there's a time period, and the court rule usually says it has to be in a reasonable time period, or it has to be within a year, and that's if it's mistake or newly discovered evidence, or if it's based on fraud. So we do have time frames to actually file these, and it's like you use it or lose it. Now the court can grant extra time, but I have not seen that, and it specifically says reasonable time period. And if you're doing a motion for a new trial, then you have to do it within 21 days after the final order has been entered.
Okay.
So there's a lot going on there. And so I would always suggest, if an individual, and the reason why it's an interesting topic to me is because there's been so many of these motions lately due to the fact that maybe someone didn't disclose something, or we're defending something, or they're trying to say it's excusable neglect, or then they also have what is the last factor, and that's basically anything but the kitchen sink. So if it's reasonable, right? So that's kind of interesting to me. So, but there's case law on it, and it's very difficult to have a judgment of divorce overturned. And in fact, whenever you do a motion, you have to provide a very lengthy brief. I'm pretty well known in the courts for my briefs because they're kind of long. I believe that's why they initiated the court rule of 20 pages or more, or 20 pages. That's it for.
Is it called the Kristina Lyke rule? Because that would be, yes, I would say that's probably because of you then.
My mom always says it's because of me, because of the fact, she goes, those poor judges, they have to read all what you write. So,
from a fellow wordy person, I understand.
But you want to be thorough, and you want to make sure that, and especially, if you have cases that are 3 years old, and normally, folks, my cases don't go that long because we have mediation and things of that nature. But when you have 4 attorneys on one side, like one attorney decides to withdraw, the next attorney decides to withdraw, you're on the 4th attorney, it delays things. And so the court will give adjournments, and then the court, has their time period of having a court session. So usually it doesn't take 3 years, but this has been, one of my cases has been a very lengthy case. And so that was one that we did a motion on, but I can't specifically tell all the facts because it's privileged information.
Oh, sure. Understood. Recently, the Supreme Court issued opinions on several different cases around end of June. So real recently. Are there any that you believe that are pertinent to minor children and parents?
Yeah, the first case that I saw that came out, and I'm going to look at my notes here for a little bit because I want to make sure I got this right.
Yeah, well, it's very new as well.
It was in June 25th of 2025.
Yeah.
And it was called Muhammad versus Taylor. And this was actually a 6-3 opinion with the Supreme Court. And I thought this was interesting because this involves like parents and also children too as well. But what happened is there was a school board, and they were having the children be read to with like transgender materials, like storybooks, things of that nature. And these parents were very upset about that. And they were Catholic. I think they were Roman Orthodox. And then there was also Muslim too as well. So all these parents decided to try to get an injunction. And they had to appeal it all the way to the Supreme Court just to get this injunction so that they could have their children bypass that, so they did not have to partake in that subject matter because of their religious beliefs. Well, the school board said, no, this is, good because, I'm paraphrasing here, but it's objectionable material and it's good for the kids to understand and things of that nature. Well, the Supreme Court looked at it this way because we take the First Amendment very seriously. And what the Supreme Court said was this, is that the court ordered the injunction itself. And the parents, what happened is the Supreme Court held in favor of the parents and relied on the Wisconsin versus Yoder case. And that's a 1972 case, which the parents having the right to direct their children's religious upbringing. And that's a big thing because we want parents to be able to have those rights to bring up their children, right, and their religious viewpoints, because that is your First Amendment. And that right can be undermined by laws that threaten their religious beliefs. So the court found that the parents would suffer an unconstitutional burden if they were forced into having their children sit down for this educational piece that the school board would not allow their kids to sit out for. Mm-hmm. And I'm surprised that it went this far, though, because I recall when I was younger, they had these sex education videos in school, and I remember there was like little bypass notes that you had to get your parents' signature on there and consent form. But if your parents didn't want you to, then guess what? You're not going to be watching that video, or you're not going to have that educational piece. So they allowed that, and so I'm really surprised that it went all the way up to the Supreme Court to get this decision here. And the court didn't just grant the injunction, but it instructed the school to inform the parents when these types of books were actually being used, that they have to give them notice so that they can actually excuse their children. So they put that extra caveat in there. So okay. I thought it was a very pertinent case because it deals with children and it deals with the rights of the parents and also your First Amendment.
So as far as having these orders changed and whatnot, is there, I know there's obviously time periods you have to do all this, but how does that time period or that sort of flow kind of unfold? How does that work?
That's a great question. So let's say that you have the final order. In fact, I just had a case like this 2 weeks ago, and we have 21 days, and you want to tickle that on your calendar. And first, you always send out a letter to your client explaining what this order is and telling them what their rights are and things of that nature. And then I always call them the next day after it sinks in a little bit and ask them, do you want to do a motion for reconsideration or a motion to go and set aside this order, right? I actually go through all the factors. And what I do is I look at the order itself and I look at what the opinion of the court is. And then I base that opinion on what kind of factor I can use in the court rule to go and do a motion to set aside. And there might not be a factor based on the case law and things of that nature too. That's something that you have that 21 days to go and look into, but you don't really have that 21 days because you have to start writing that motion. You have to draft the motion. You also have to draft the proposed order in of itself and also a brief. And that's just for a motion for reconsideration. That's another way of handling an order if you didn't want this order to be final. And that motion for reconsideration is unique because the other person does not respond. So the opposing party will not respond, and the court rule says does not respond, right? So you send that into the court, and the court reviews that, and they can either say, yes, I made an error, and this is, I'm going to order what you asked for in this, or you're not, or it's going to be denied. And a lot of times motions for reconsiderations, I will tell you, it's a long shot. So you want to be very careful, because you don't want to waste your client's fees, and you don't want to waste their money. But it also helps them too with the appeal process. There is, like I said, an order doesn't have to be final, because there's a appellate time period too. And I don't practice appellate work. I practice just litigation. So I always send them over to a friend of mine that does a wonderful job on appellate work, because you really don't want a litigator and coming into an appellate work, because there's different things that we see as attorneys, and litigators are completely different than appellate.
Yeah, so, I've often found that interesting, that there's like a very specialized appellate sort of niche within the law community.
Yeah, and the litigators seem to be a little louder. We seem to, be the extroverts a lot of times.
Sure.
But and we can't sit still in the court, right? But as to the motions to set aside or get relief, another thing I would say is that there are different avenues that you can go and take. And whether it be a motion to set aside if it was fraud, if the other opposing party conducted fraud upon the court or upon your client, you want to make sure that you talk to an attorney. And, I'd be more than happy to sit down with anyone that has a question, but we have consultations for that. And those are huge issues. And I want people to understand that not always your order is final.
Mm-hmm. All right. Well, great advice as always. Thank you for joining us today on the Legal Beagle. Get the help you need at likelaw.com. And don't forget to subscribe to our channel. Leave us a review. We very much appreciate it. Kristina, it's always great to see you. Thanks so much for being here.
It's great to see you. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.